Colin O'Keefe here for LXBN TV. In one of the biggest Supreme Court cases this term, the justices ruled this morning against internet television startup Aereo, stating that they had violated copyright law by streaming broadcasters' content without their permission. Joining me now to share his analysis of this ruling is our go-to source on this case, that is attorney Kevin Goldberg. He is with Fletcher, Hildreth, an author on their excellent law blog. Kevin, I know you've worked your way through this opinion, so let me get your thoughts. What are your initial impressions of this ruling?
Well, it's somewhat what I expected after I had attended the oral argument, and I know we talked that day, and I said that I thought that the Supreme Court was looking for a way to declare the Aereo service illegal, but preserve cloud computing, and it seems pretty clear that that's exactly what Justice Breyer did, writing for a 6-3 court. In fact, even if you look at the dissent, I'm not even sure we can call it a dissent, where Justice Scalia, joined by Justice Alito and Justice Thomas, seem to say, look, even I think that Aereo is pretty fishy, and I'm not sure they're doing anything that is legal, but I just don't think you could say they're engaged in direct copyright infringement, which is what the question was before the court and what the court was asked to answer, and therefore what the majority opinion had to take head on. But that is what the majority opinion said, that Aereo is engaged in the direct copyright infringement of the broadcaster's copyrighted content.
I see. And then second, you mentioned there that they've really tried to limit the scope of this ruling, as they frequently do with these landmark cases. But of course, in the lead up to the oral arguments and then the ruling, there had been much concern from the mainstream media that a ruling against Aereo could potentially spell doom for advancement, technological advancement for television broadcasters. So let me ask, is that concern a bit overblown, or just how limiting is this decision?
It's actually very limited. Again, when you look at it, both the opinion and the dissenting opinion, especially more so, maybe it's perhaps wishful thinking by Justice Scalia, he's quick to point out that this is about the direct copyright infringement allegations based on Aereo's public performance of the broadcaster's copyrighted content, and specifically the ability to watch that content live. So there's a lot of different things that actually weren't before the court, such as any contributory infringement, such as any liability predicated on the reproduction by Aereo, such as anything that might occur from the recording and later viewing by Aereo subscribers. And none of that was before the court. So in one sense, it's a very limited holding, but as you read Justice Breyer's opinion, anything he says could be applied to anything Aereo does. The only thing I'll hold off on is Justice, and even Justice Scalia, I'll say, does sort of agree that in those instances, Aereo doesn't seem to be doing anything but infringing the broadcaster's content. But, as he also says, the one sort of thing that's left open is, what about someone who's an Aereo subscriber that records and watches once the program is over? How do we handle that? And there's this sort of little opening for Aereo to fight this later on. I don't know if they will. I don't know if that'll be closed pretty quickly as it goes back down to the Second Circuit and then to the United States District Court. But that, to me, would be the one area that Aereo might be holding on to.
I see. It's going to be interesting to watch, to see what the implications are, and then of course to see if this is the end of the road for Aereo, or to see if they keep on fighting. Once again, that was attorney Kevin Goldberg of Fletcher, Hildreth. For more of his insight on this case, be sure to watch out for their full post on it. That'll be coming at comlawblog.com. Thanks for joining me today, Kevin.
Thanks, Colin. Always a pleasure.